distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, old folks. It is Tuesday. I have time for for a stream. How about that? Now, I was on Nate the Lawyer's channel. What is it? Hour ago, and I'm so glad to see that he is doing better, and that the surgery was successful as it could be under the circumstances. He revealed to us that during his brain surgery, they could remove 90 to 95% of the brain tumor. The rest is sort of intertwined with some blood vessels. So they will try to remove it with chemo and radiation. But so the next 4 months or so will be recovery and treatment for our Nate the Lawyer. So good luck to you, Nate. You got through the really dangerous part. Now you have to get through the rest as well. But I mean, the way people have come together for him is amazing to see. Now, this stream. Kelsey Fitzsimmons. For you who don't know, Kelsey Fitzsimmons was shot in the chest by a fellow police officer. The police officer claimed she pulled a gun on him. She claims no, she pulled a gun on herself because they were trying to take her baby away, which they, well, of course, succeeded with. Now, the grand jury didn't buy the police story at all, since they tried to get her charged for more or less attempted murder. The grand jury said, oh, hell no. So now she is charged with what was it now again? Something with a dangerous weapon. So they didn't believe the prosecutor that, with the evidence they had at the time, that no, we are not buying it. So she was shot in the chest. She has had major surgeries, many of them, and she put up bail, and a few days after, because one of the conditions for the bail was she had to do this so-called scram test, where you blow into a tube to prove that you're not drunk. She was shot in the fucking chest. Of course, it's going to hurt like very, very much. So her lawyers went back to court and said, can we amend this so she does? There are other options. And the judge became so offended, she put Kelsey back in jail. And that part where the attorneys are trying to get her out of jail again, because Kelsey Fitzsimmons is a law enforcement officer and a former correctionals officer. Being in jail is fucking dangerous for her. Okay? But while this is ongoing, pre-trial is ongoing because she is set to stand trial sometime next year. So what we are going to see now is pre-trial hearing. Yeah, thank you, Dark Lotus. And she still has fragments of the projectile still lodged in her chest. This is one of these cases where you wonder, what the fuck? And, by the way, through the rumor mill, Kelsey Fitzsimmons' ex, who caused this entire situation by calling in a wellness check, is apparently getting himself a PR representative. Because apparently, well, let's back up a bit. Not much. He impregnated. They got pregnant. They were boyfriend and girlfriend. She had the kid. Somewhere in there, he broke up with her because he didn't want to be around because she got postpartum depression. So he abandoned her and the child. The fucker. And quite soon after, he has a new girlfriend. Of course he has, because apparently abandoning your child and the mother of your child when they are in hardship, that's not enough of assholery. So he got himself a new girlfriend. I mean, we're talking about weeks here, apparently. So he called it in a wellness check because he discovered, maybe I want that child anyways, but not her, because she's in a bad mood. And that triggered this event where cops, CPS showed up. Hey, what's going on here? And she, of course, postpartum depression, got scared, and according to her defense, she pulled a gun at herself. And doing so, she was shot in the chest by her colleague in the law colleague. And for me, one of these things that tells me that the cop is lying is that if she pulled a gun at him, he would have emptied that magazine in her. But he got scared and shot her in the chest once. And luckily, she survived enough to tell her story, because if she was dead, all we would have heard was his story, and he would have been believed because she would have been dead, but she survived. There are no body cams, there's no nothing. So yeah, so that's the situation, very crammed up together. So, of course, that is ongoing with the defense attorneys trying to get her out of jail, out of that extremely dangerous situation for her. I've heard that too, but I haven't seen it on paper. I hope it's on paper somewhere, but I haven't seen it yet. That, as Jen says, I thought he first said she pointed at herself and then changed the story. Yeah. Because if that can be proven, then he's fucked, and Kelsey Fitzsimmons should have a better chance at trial. So this is a pre-trial hearing, and it is from today. Now, this pre-trial hearing was during when I was on stream with Nate the lawyer. So I couldn't stream it live, but I can stream it now. So let's get to it. The Kelsey Fitzsimmons pre-trial hearing. Let's hope that's good sound. Putting on sound enhancer.
Hello, Your Honor, Timothy Braille on behalf of Kelsey Fitzsimmons.
Oh, that's really bad sound.
Judge, can I ask as a preliminary matter if Ms. Kelsey might be permitted to join us? Ms. Fitzsimmons might be permitted to join us.
And thank you to Young Yerks for Jesus Christ.
All right, if I need some time with her, doesn't seem like.
Well, sure, of course you can. You can go talk to her.
Very good.
Okay, so this is on for trial assignment today. I indicated-
I'm lowering my microphone here so you can raise the volume.
Try it anytime. So let's do that.
So Judge, a couple of things on that. We think that's a little premature for several reasons. I have 3 outstanding discovery.
Folks, I have 2 sound enhancers on at maximum. I lowered my microphone so you can raise your volume. Hopefully we get better sound soon, but then it will blow our ears off.
That sort of are, stepping stones to getting ready for trial.
Having filed?
Yes.
Okay.
So 2 of them were filed on August 26th.
Okay.
And the other one is, and I'm certainly happy to give counsel for Commonwealth some leeway. This was filed, I believe, last week, November 21st. And so if counsel needs more time on that, I certainly don't have a problem with it. And I will grant you, I'll acknowledge that the Commonwealth's given me a pretty fair amount of information that we're going through. But as you can imagine, and as I know you know, that sort of begs further questions about more discovery.
Well, I have one motion here for specific discovery.
Well, we filed 2 motions on August 26th, and I have copies of them here.
What are they entitled?
There's a motion for court order disclosure and release of arraignment, and there's a motion. The Commonwealth may well be in compliance with some of that or most of it, but and so those are really the first ones, Judge.
What is that?
Jesus Christ.
Sorry.
Okay. The camera is allowed in the courtroom, but it has to be silent. No exceptions. Thank you.
The first one is the motion for exculpatory discovery, and that is essentially a Graham McFarland request regarding certifications by the officers, whether there's any prior incidents. And that is a predicate to a Rule 17 for that, so that we have a good faith basis, if any, to file a Rule 17 for any further information. And my brother's telling me that that's fully complied with.
Okay.
And I'll defer to him on that.
Okay.
No, I think I complied with my obligations under the.
Okay.
As far as that first motion, there are things in there that I in the first motion that I do not agree to,
Okay,
and we can go through that if you'd like, but other than that, we have a list of questions that we ask every potential witness, police officer.
Right.
Database, but that has all been complied with.
okay.
But if he wants to talk about the first motion, I'm happy to do that. No action has been taken.
Which, when you say first, I've got three motions here.
Motion for exculpatory evidence.
Okay.
Exculpatory discussion.
So that's essentially what we're talking about, Judge, the Graham McFarland request. And, you know, it's also obviously a Brady request as well. So I think it's more than just, you know, Graham McFarland. It's any exculpatory evidence that's known to the Commonwealth, whether it's the Commonwealth prosecution team or
Well,
the police team as well.
so, Mr. Gubitosi, the motion for exculpatory discovery,
Yes,
what is it that you object to?
I object to number 1C.
Okay,
Okay, what's going on here? Let's see if I can get my mic a bit, since there. What's going on here is that the defense claims that there are discovery that they are obligated to turn over. Now, the prosecution, of course, says, no, we're not. Hopefully, they will go into more detail about what it actually is that they are objecting to handing over. For me, I mean, my standard opinion is, if the prosecution have it, turn it the fuck over, and then we will see if it's exculpatory or not.
Number 1D, number 1H, I,
okay, hold on.
and J.
C, D, H, I, and J.
And then that's on number 1.
Right,
Number 2, he wants me to certify in writing that I have made inquiry of every prosecutor in my office for all items and information favorable to the defense. I don't think I have an obligation to do that.
right.
We did that on every single case. We do have a database. We do have a process. We do ask each individual officer these questions, but we do that on every single case
Right.
in the county. That's thousands of cases to some 80 some odd prosecutors
Right.
every day.
Well, and it doesn't include all of the prosecutors that have passed through the office, that have come and gone over the course of the years. Are you suggesting, Mr. Bradel, that the Commonwealth needs to contact each and every prosecutor that has ever worked in the district attorney's office throughout the officer's tenure?
No, Judge.
Well, that's what the motion asks for.
No, it doesn't, Judge. It asks them to have, maybe they could use a computer database. Maybe they can log, just like, you know, lawyers have record-keeping responsibilities. Lawyers have conflict checks. There's all sorts of things that are precedent for this kind of a thing. When a prosecutor has a case where some questionable police activity has arisen, prosecutors can easily document that in this case, Officer Jones was found to be not credible by Judge Smith.
Well, I understand that,
Be
but
locked.
let me start with I. Whether the officer has signed a search warrant, I probably see 2 Frank's hearing requests a month in this session.
Folks, this is Judge, or what's his face? Well, this judge, before he became a judge, was a police union attorney. He's kind of known for being very nice to cops. I hope that won't be an issue in this case. Because, sir, she's a cop too. Well, yeah. Now, everybody with a law degree should be able to become a judge. But if your career up until a certain point was solely defending cops. Yeah, I don't know. I hope he can be unbiased. I really, really do.
2 or 3. Most of them are not allowed. Occasionally they are. And just because there is a Frank's hearing does not mean that there was a finding that anyone gave any false information.
Sure.
So how would anyone determine that?
Well, Judge, again, these are record keeping requests. And
But who keeps a database of that
so
for the last 10 years?
when you're a prosecutor in a district attorney's office and you finish a case, you're required to follow office procedures to close out the file.
Right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
It's up to me to decide.
Did you work in the Essex County DA's office?
Judge, I did not work in the
Okay,
Essex County
so
DA's office, but I do
From
know a
when,
little bit about it.
what are you speaking about when you say that this is how a DA's office ought to be conducting itself? What's the basis for that?
Judge, okay. I don't think it's a obscure proposition, Your Honor, that when a public agency such as the district attorney's office has to close out a case, that they have to comply with record keeping obligations under the law.
But
under FOIA, under record keeping for all sorts of things about what happened with the case.
Well, I understand, but Mr. Gubitosi has represented that he's gone back and searched. They have a process. I'm sure that he'll advise you as to what the process is. And if you want to critique the process, that's up to you. But in terms of them producing evidence that is in their possession, custody, and control, he can only produce what he can search for. And the fact that you disagree, maybe you do, with the way in which they keep records or the type of records that they keep is not an issue that I'm going to decide. I don't know of any case law that says that I'm the one, or you for that matter, to decide how the district attorney's office keeps records. And in fact, I'm not going to order anybody to retroactively go back and search records from, I don't know how long the officers who are witnesses in this case have been police officers in this.
Why not, Judge? Why should if there is a record, say a judge 7 years ago said that to one of the testifying officers in this case, hypothetically, a judge says, "You are not credible, get out of my courtroom." Why wouldn't that be now on the record? Easily obtainable for the defense. A Brady list, so to speak. Now, the assumption here is that the prosecutor is honest. The assumption is that the prosecutor actually went back and looked for these, I don't know, 5, 6, 7, 8, 9 cops, however many of the cops that are testifying, who are going to testify in this trial. The assumption is he actually looked for these kind of things. The assumption is that. Problem is, it can't be controlled, or it can't be checked. You have to trust the prosecutor's word, which you should. But folks, we're in fucking Massachusetts here, okay? At the credibility level, they are not high up on the credibility level after the past few years of shenanigans involving cops, right? But I understand how the judge is thinking, because he kind of have to. Because the assumption is that the prosecutor is honest. Now let's see. Sebastian Miller, member for 23 months, almost 2 full years. Thank you so much for your continued support. How have your weekend been, Nick? It was good. The latest nephew got baptized, or Christian, whatever it's called when a baby gets water on his head and we pray and stuff like that, So it was a good weekend. It was nephew number 17 or 18, something of the sort. Konya Schmidt gifted 5 memberships. Thank you so much. Was gifted to Been There Done That, DSN 385, Doodlebug, No Thank You MK, and Arizona Techie. Hey, thank you so much. That is very, very generous of you. Thank you so much. So yeah, I understand the judge that you have to trust the prosecutor. My problem here is I don't trust any prosecutor, especially a prosecutor that was more or less told by the grand jury to fuck off, stop bugging us with bad cases, and they are still moving forward with this trial. All right, let's continue.
County, but do you know Mr. Gubitosi off the top of your head?
And one of them is 20-something years.
Yeah, so I'm not sure that I can ask them to search records they don't have, but there is a, whether the officer has ever attended or presented at a law enforcement training by the private vendor.
Just before we jump off of that one,
Yeah,
all the Commonwealth has to do is ask the officers. There's 4 officers that were at the scene. They can ask.
Seriously, Mr. Prosecutor? All we can do is ask the officers. How? Under oath? Swear under a penalty of perjury? Or just, hey, have you lied in court? A cop who is truthful and honest will say no if they haven't. A cop that is untruthful and a liar and a scumbag will also say, of course I haven't. That's stupid.
Ask 4 officers, were you ever involved in a Franks hearing? There are ways to do this. We don't have to act like this is some obscure thing, Your Honor. This is exculpatory evidence. We have every right to all these things under Graham McFarland and under Brady.
what case says you have a right to find out whether any police officer on any case has ever refused to answer questions?
A police officer in our case, Your Honor.
No, in this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions? There are a lot of reasons for that, I can assure you. And I'm not aware of any records that are kept of that. And I can assure you that it would never be admissible under any circumstances.
Yeah, dear reader, no. Yeah, I would say Giglio has something to say about that. Now, it's different. Not answering during a Franks hearing is a little bit different than pleading the fifth. It all depends on the circumstances, but yeah, Giglio. Yeah, you have to disclose things that are exculpatory in order, that's, or the possibly exculpatory. And if an officer has been in a Franks hearing where they refuse to answer questions, yeah, that goes to the credibility. That should be impeachment material. Yeah, Giglio. Yeah. Thank you, dear reader, normal people. Thank you. And hello, Slidy Pie over at Rumble. Yeah, I am streaming this on Rumble X, and YouTube today.
So I'm having a hard time with the concept that the DA's office or the police department has to supply you with the fact that an officer 15 years ago declined to answer questions after a shooting at the scene, but 2 days later answered the questions, for example. Happens quite frequently. So I am reluctant to say, I doubt there's any police agency that keeps records like that. I don't know of any.
What? Yeah, but isn't that a problem, Your Honor? That departments doesn't keep track of it? Isn't that a problem, Your Honor? That you don't know about any department now, and you should know because you have been half of your legal career. You were a police union lawyer, so you should know.
But certainly the district attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer takes the fifth, so to speak,
Okay.
it's been found that a truthful answer would incriminate them. So it's incriminating information.
Who's made that finding? That's an interesting concept because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person had a Fifth Amendment privilege or not. My experience has been that the department offers people a rights form, and if the department has made or ascertained that the person has a self-incrimination right, far be it from a lawyer to question that when the prosecuting or investigating agency is doing.
In the middle of this, he has a point. Does a cop have a Fifth Amendment right at all? I must say I don't know. But it's kind of besides the point. If they have it or not, if they refuse to answer questions during a Franks hearing, that is equivalent to pleading the Fifth. So I don't know if it really matters if a cop pleads the Fifth or not, or if he has the right to plead the Fifth. If that cop still does it or simply refuses to answer questions, then that should be treated as self-incriminating in a criminal setting.
That. So again,
It's built into the law of the Fifth Amendment, Your Honor, that you can only take the Fifth Amendment when a truthful answer will incriminate you.
that's assuming you're ordered to, and that's assuming that the order also encompasses the nuances presented by the state constitution, which requires transactional immunity to overcome it under Carney versus Springfield. So it's not as simple as you make it sound. But let's get back to the fundamental issue. Does the district attorney's office keep records of any officers that have ever invoked their rights at any proceeding that the district attorney's office is aware of?
No.
Okay. And if, with regard to the police department, Mr. Bradel, I'm not aware of whether they keep records of that or not, but I am certainly familiar with the fact that even if that were true of a particular officer, it certainly is not admissible.
Judge Rand McFarland has a whole host of things that are not admissible, or an optimistic defense counsel
Right.
might say not yet admissible, but that's not a exclusionary factor, Your Honor. So you can't really go there. And these are all, we don't need to pretend like the officers are in Alaska. They're down the street.
No, I understand.
Commonwealth can ask them all these things.
But does that case say that all records pertaining to an officer, any officer who has ever invoked his or her rights, either under the Fifth Amendment or Article 12, records have to be kept and they have to be disclosed? Does the case address that?
It does not say anything about.
Does the case address whether or not an officer who is the subject of a pending internal affairs investigation unrelated to the matter that is before the court, that those records need to be produced?
Yes.
Okay. And what about whether the officer has ever testified in a motion to suppress, which the motion was allowed because the officer it's pretty broad in terms of violating the defendant's rights, but assuming we could refine it a little bit, does the case say that you must produce that? And who's charged with keeping those records?
Your Honor, Brady says we have to produce that. The Constitution says we have to.
On any motion to suppress that was ever allowed?
If an officer is found to be not credible,
See, we're talking.
Well, hold on, those are two different things here. The fact that a motion to suppress is allowed does not necessarily mean that an officer was found to have lied or made false statements. There are two different things. People make mistakes. The purpose of the exclusionary rule is to deter police conduct, but not every motion to suppress is allowed because a judge finds that an officer lied. Yes, the motions are allowed because in the court's judgment, for example, a stop was unjustified, but that doesn't mean that the court found that an officer lied.
that's.
In fact,
not
I'd
what
say
we're
most
talking
of the
about.
time, that's not.
We're not talking about a legal ruling about an officer's conduct. We're talking about when an officer's been found not credible. And that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
Yes.
Okay,
And so,
Yeah.
and he's being cute, because what he's writing in this motion is much different than what he's saying.
did you check the database for what I just outlined?
And we asked these officers, and he knows this, we asked these officers a whole host of questions.
Okay.
About whether they have convictions, or convictions
Sure.
for facts, about criminal offenses, adverse credibility findings against them from any court.
Okay.
Pending criminal investigation into your conduct, findings that you have engaged in bias, racial,
Okay.
profiling, discrimination.
Okay.
crime, Findings that you have engaged in untruthfulness or other misconduct. Implicating credibility.
And have those questions been asked of the witnesses in this case?
Yes. and
Have you provided any information that's responsive to those questions?
yes, there's a
What's the
lot.
complaint, Mr. Bradle?
Well, that's what I'm asking, is if it's complied with. And
Just said it was.
I'm saying it was, and counsel got up and seemed to be wanting to correct me on that. And so here we are.
Okay.
So is it complied with or
Well, it's
not?
on the record. What else do you want?
The motion speaks for itself, Your Honor. I just want to know what the Commonwealth is objecting to.
Well, Mr.
They gave us a list and we can go through it.
The list of questions that you asked?
Counsel objected to 2C. Have they ever refused to answer questions citing their constitutional rights? We had a little bit of a debate about that. I think that's, Judge, a firing offense. I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's
In the absence of
exculpatory.
transactional immunity, officers have been fired?
I think it's
You should read
exculpatory.
Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge, I think that an officer that takes the fifth in this case about something else is saying, if I answer that question, a truthful answer will incriminate me. So I
Well-
think under Graham McFarland, I think that's certainly
The case doesn't say
exculpatory and
it.
discoverable.
The case doesn't say it. I don't agree with you. Carney versus Springfield says otherwise, okay? And I don't agree. So, Mr. Gubitosi, have you provided a list of the questions that you have asked to the officer, or can you, or will you provide the list of questions that you asked to defense counsel? Okay. And Mr. Bradle, if the answer to all of those questions is no, and they've asked them, I'm not seeing,
Hold on here. Didn't the prosecutor say that he had provided all this information and now all of a sudden he will provide this information? I see the prosecutor is talking out of both sides of his mouth, because you can't, if he claimed to the court that he had complied with this, that the defense has this information. All right. So why do you now have to send him the information? That means you haven't complied.
anything that would indicate otherwise in this case, then you need to examine the questions. And if you feel there's something that wasn't covered, then you can refine your motion. But I am not going to allow, and I don't think I agree with your view of the law, that whether or not an officer is refused to answer questions, citing constitutional rights is something that you're entitled to. In the immediate aftermath of critical incidents, officers often advantage themselves of the fact that the police department does not have transactional immunity so that they can have an opportunity to speak, sometimes within 24 or 48 hours. Happens all the time. And in fact,
Your Honor, why are you arguing for the prosecution? Yes, we understand you have much experience with police procedure because you defended hundreds of cops, if not more, during your many years as a police union attorney. But you're a judge now. This information should come from the prosecution, and then you make rulings. Even though judges can talk out of personal experience, but as of now, you're arguing the prosecution's case for them.
officers are often interviewed thoroughly thereafter. So the case does not say that if you refuse to answer questions, it is fireable. In fact, it says quite the contrary. The police department does not have the ability to grant transactional immunity. Only the Commonwealth of Massachusetts, the district attorney's office, or the attorney generals have that ability. So to suggest that a chief of police or commissioner could fire someone for invoking their rights without giving them transactional immunity is incorrect. And so as to the extent you're asking for that, it's denied. Now,
The next one is D.
yeah,
Whether the officer is subject of a pending internal affairs investigation or any internal affairs investigations into the officer's conduct, whether these have resulted in sustained findings of misconduct. I'm not sure why there's an objection.
Well, the way it reads is different than the way he said.
okay,
If there is a sustained finding, absolutely.
sure,
And,
okay,
and there hasn't been in this case.
okay,
With any of the officers that are involved.
okay. So that's the answer to that. And as far as the other questions, it seems to me H and I are covered by the questionnaire, but J,
Well, no, if I might just, H and I, if you're gonna deny them, but they're different than what he's saying.
no, I is only, you only need to respond to I if there's been a finding by a judge that there was a misstatement in the search warrant affidavit, not whether or not defense counsel has filed a Frank's motion, because that happens routinely, and routinely the matters don't even reach an evidentiary hearing. And even if they do, it often doesn't result in a finding that there was any untruthfulness. So yes, if there has been a Frank's finding by a judge that an officer, any of these officers, made false statements in a search warrant affidavit, yes, you've asked about that, and yes, that has to be produced.
Of course.
Okay.
But H, if we can just get back to that, because we talked about that a little. And if the way counsel is talking about it, if there's been an adverse finding of credibility, of course we turn.
Yes,
That's a no-brainer.
Right.
We do that.
But-
But that's not what that said.
no, not every, I am not going to order the production of any motions to suppress that were allowed for any reason. First of all, it's almost impossible to ascertain that. And secondly, how many district courts in this county, Mr. Gubitosi? 7. Well,
Yeah, but you can ask the officer, Your Honor.
Well,
The officer is
he
right
has,
there. You
and
can
if
say-
there, I agree with you. If there was a finding that the officer made a false statement, you're entitled to that. But the fact that an officer thought that he or she had reasonable suspicion to conduct a pat frisk and a judge disagrees does not mean that the officer was found to be untruthful. But
I
yes,
agree
in
with
the,
you. We don't
in the
need-
course
we don't
of-
need to debate it. I agree with you.
okay, so I think we're fine. Now, Jay, you know,
But but why not disclose that? Why is it so harmful to disclose such a thing to the defense? Because that would be a question for the jury. If the case is so ridiculous that the judge said, yeah, I don't agree with it, it doesn't mean that the cop was lying. It just meant, yeah, I don't know. But if this happens repeatedly, then it becomes an issue. But it's hard to impeach a police officer witness on these issues if the defense are not allowed to find out about it.
I just have no idea.
I have no idea what that is.
Okay, and then they can answer that. They don't know about it, they don't know about it. That's the answer. I'm happy with that.
Okay. Now, is there, Mr. Gubitosi, when did you get meeting 35, the motion for specific discovery?
Friday.
Okay. Are you prepared to respond to it?
I can try to.
Okay. Is there anything in there that you object to?
Yes.
Okay, and what is that?
Again, there are portions of number 2.
Mr. Jingles joined the
I
stream.
will provide all witness statements.
Okay.
That's pursuant to 14, just overbroad.
Okay.
Number 4A, excuse me, 4 is asking for any and all footage from the North Andover Police Department on June 30th during the time of which this Fitzsimmons was at the station. And we've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But it just doesn't save longer than I think it's 30 days.
Okay.
Yeah, the defense asked for video footage of things that happened at the station. As it turns out, the police station have an auto delete on everything, every recording, every video recording. 30 days auto delete. For the life of me, I don't know why that is legal. That police departments are even allowed to delete video footage. Especially, I mean, there's always crimes going on. And there is, especially in the case, there's always crimes going on. There will always be questions. Did the police act as they should? Did they say anything incriminating on recording? But if you have a 30-day, I mean, first of all, she was shot. She was charged, she got an attorney, and then the attorney files a motion. Already there, you're past 30 days. You're already past 30 days, and conveniently, all the recordings that could be useful for the defense are gone. I would say any police department who has auto delete on, do it because they know they're dirty. A police department who is not scared of anything and who wants to weed out bad cops would never have auto delete on their recordings. But this department does. Now, when was it implemented? We don't know. Why don't they, even if it's, yeah, I don't know. It's very, very convenient. It's very, very suspicious. And for me, it's clear as day that a police department that actively chooses to auto-delete does it because they know they have bad cops.
If something doesn't exist,
But,
then,
but the last paragraph, the last sentence says, the name and contact information of any officer that interacted or observed Ms. Fitzsimmons at the time.
okay,
Well, she has that information. Who she interacted with,
Right.
November 30th of 2025 at the station, so, that's something.
well,
that-
first of all, maybe I'm missing something, but other than in the interview room, when someone's advised that they're being recorded and you know, they're taped, I'm not sure there's,
No, I think this is, she didn't go to the PD after the event, she went to the hospital.
okay,
For the event, it's my understanding, and this is only from what defense counsel told me.
Yeah.
That she was at the station earlier that day.
oh, okay.
Had, done something, I can't remember what, during the day.
Was that the station earlier, Mr.
But she
Bradel?
knows who she interacted with.
Okay, is June 10th, June 30th the date of the incident, by the way? Okay. And when was she at the station and for what purpose? What time does the incident happen?
So Your Honor, the incident is, it's in the afternoon of the
Yeah.
30th. And prior to that, Ms. Fitzsimmons was at the North Andover Police Department for a CPR recertification.
I see,
She brought the baby with her.
okay,
So we wanted the video
Yeah.
from the station. And on August 26th, I think the Commonwealth's going to have an issue with this, okay? On August 26th, we filed these arraignment motions.
Right.
Asking, we put them in abeyance except for some of the more obvious ones like
Right.
preserve notes, preserve video,
sure,
tell people who are video holders to hold on to the video. That was August 26th. So the
Okay.
Commonwealth was on notice as of August 26th.
Yep.
The video, I am fairly certain, was present and available then when they were given notice of this motion, and I believe the court allowed those preliminary requests.
well, there are two issues there. First of all, though, when you say August 26th, was that filed in this court
Correct.
when she was arraigned?
Yes.
Okay. And Mr. Gubitosi, do you know, first of all, I don't know because not that familiar with the North End.
All right. So it's always nice to find out something new. So within that 30-day span, the defense put the prosecution on notice, and the department, the police department, saved the things. And they didn't. That's a huge issue. Who took the active decision to not preserve those things? Oh, by the way, folks, hit the like button. You know it. It's the common YouTube thing is go in here. If you're here and you have been here for more than 5 minutes and you haven't pressed the thumbs up, you haven't done your part of this bargain. Okay? Okay. Oh, and thank you to Dear Reader Normal People for gifting a membership. And it went to M40A5. Should that? Okay, thank you. Thank you so much. And I got rated. Thank you, Kat. Thank you, Kat. We are watching the Kelsey Fitzsimmons pre-trial hearing where the defense is trying to get information from the prosecution that they say, hey, we need this. We need to see if any of the cops who were witnesses to this event, if they have at some point in time been in a Frank's hearing where they refuse to answer questions. Apparently, the department does not keep record of those things, and certainly not the district attorney's office. And the judge went on a long rant because this judge is a former police union attorney. Yay. And now they are asking about videos from the police department. Now, the police department have auto-delete. 30 days auto-delete. But the defense asked for preservation before that 30-day had passed from the event to when they asked for it. So the prosecution was on notice, preserve it. And they didn't. That's an issue. So that is what they are debating right now. And thank you, Kat, for rating. Thank you so much. And hit the thumbs up.
Over a police station, whether or not they even have cameras that would have videoed the presence of the defendant at the station on that day.
They do.
Okay. And do you know how often those are recorded over?
Not at the present time.
Okay.
I did. When we spoke about it, I called.
Back in August?
It was on, I can't remember.
Okay, okay. So the issue then becomes whether or not the request was made. First issue is whether or not you're confident the video doesn't exist today.
Correct.
Okay. The first question is, I think that the defense counsel is entitled to know when the video, how often they tape over. I mean, I hear.
I did tell him that.
Right.
When I found out, I just can't remember.
But you can.
I can just suggest, Judge, if I may, I looked at, counsel's trying to accommodate, so I
Right.
appreciate that. But on 9/18, counsel told me that they only had it back to July 5th,
Okay. And you made the request on.
8/26.
Right, but that doesn't answer the last question, which is whether or not at the time you made the request, it still existed or not. But Mr. Gubitosi, that should be easily ascertained.
Absolutely.
Sure,
I
okay.
think if you do the math, it looks like it is. And again, I appreciate the Commonwealth's efforts to try to get it. But it looks like on 8/26, if you do the same math, 9/18, it goes back to July 5th. 8/26, you're going to be within the window of.
You may, I don't know. I don't have, every video system that I've ever heard of, I've seen some that go 3 days, 7 days, 30 days, I don't know. But that's easily ascertainable. And Mr. Gubitosi is going to tell you about it.
That depends, Your Honor, because if they don't keep record of it, there's no way of knowing. And then you have to assume. Because the only person in that courtroom with rights is the defendant. Then it has to be, should be, in my opinion, that they didn't preserve it for a reason. In my opinion.
And then you can make of it what you need to make of it.
And there's no motion before the court on
Yeah.
it. I just wanted to.
Okay.
Bring it up, Your Honor, that it's very important to the defense that we have that
All right.
video.
Anything else we can, in this motion, Mr. Gubitosi, that you object to that we can address today?
Yes.
Please, yeah.
Number 6. is concerning disciplinary records for firefighters that responded to the home address of the defendant or Mass General Hospital.
And your objection to that is?
So the firefighters are not part of the prosecution team, if they're not in care, custody, control.
Yeah. I mean, you can file a Rule 17 for that, Mr.
Very good, Your Honor, that's perfectly
Bradel. I
fine.
think that's right. What else, Mr. Gubitosi? Anything else in this motion?
And for you who don't know this case at all, that is Kelsey Fitzsimmons. She and her now ex-boyfriend had a baby together. She got PPD, postpartum depression. He abandoned them, got a new girlfriend, called in a wellness check. During that wellness check, Kelsey claims that she, during this distress, pulled a gun on herself. The cop who shot her says she pulled a gun on him. So he shot her in the chest. The prosecution wanted to charge her for attempted murder. The grand jury said, fuck no, and threw that charge out. So, you know, grand jury, you can indict a ham sandwich before a grand jury. And whatever they told the grand jury, they did not believe it. So she's not charged. The only charge that is still there is reckless handling with a gun or something of the sort. So, but nobody can. No can. They deleted a 30-day auto delete on the station. Yeah, sorry. Thank you, Floyd. It wasn't a wellness check. It was an order to take the baby. Thank you. Yeah, you're absolutely correct. It was not a wellness check. I need to do a bullet point video about this case so we get the timeline correct here, because my apologies. I forgot it wasn't a wellness check. It was an order to take the baby. Yeah, Floyd's fam said also. He says the cop shot her. He says she closed the door. Apparently, there's no door. So yeah, there are some credibility issues with the statement. So not only was she abandoned by her now ex-boyfriend, he moved on really fast. Yeah, he filed a petition to the court. He got an order to take. They got an order to take the baby. I haven't touched on this case for a couple of months, so this is. I need to get myself up to speed as well. And that is why I love my chat, because you correct me when I get things slightly off. Thank you. This is also the woman who had multiple surgeries. She was out on bond. One of the bond conditions was you have to do this gram test for alcohol. She was shot in the fucking chest. Broken ribs, surgeries, all of the things. So they went to court a few days after she was released on bond to, hey, judge, please, can we do this another way? And the judge got so damn offended that that judge put Kelsey back in jail. She's now in jail. Kelsey is a cop and a former correctional officer. Being in jail is a lethal threat to her. No turnip. the judge got so offended that she had a hard, and here's the thing, she only had a hard time blowing into the tube because it hurt like a motherfucker. But it's this bond stuff is up in the Supreme Court now. Hopefully they will determine that she should not be in jail when there are multiple other things, so she can they can check her for alcohol. All right, let's continue.
Number 9.
Yep.
All statements, including text, emails, voicemails, writings, or like between or among any civilian witnesses or prosecutors. I would just say it's overbroad.
Yeah, how, Mr. Bradel, how can the Commonwealth produce messages between people who are not, civilian witnesses?
Sure, I understand, Your Honor. The request should be really a little narrower, I suppose, which is whenever there's a police prosecution team member in the conversation,
Well,
then
that's
it
different.
should be
I agree.
discoverable.
Right.
So
So statements, Mr. Gubitosi, of people who are,
Are statements that
yeah.
I'm obligated to provide. We're
Yeah.
working that over.
Okay.
I agree with that, but not that.
and just, oh, sorry.
No, I was moving on.
Just one thing on that before you move on, Your Honor,
Yeah,
is
sure.
that,
Yeah.
it's our view, we viewed on the security video from the scene that officers are texting and calling all over the place at the scene, quite understandably.
Sure.
But we just want the text messages, and we have information that there were communications between the father of the child and the police officers leading up to serving this warrant, leaving up the restraining order, rather, serving the restraining order, leading up to that. And there are communications that are between the father and the
Okay.
police that we want,
Well, if
which would
any
certainly
of
be
those
statements.
materials that are in the possession, custody, or control of the Commonwealth or the North Andover Police Department need to be produced. I can't, it's a little bit broad in the sense that, if there are people texting that the Commonwealth doesn't know about. it's kinda
I
hard
agree,
for them.
Judge. I don't even want to, yeah, I can cut to the chase on that.
Let me
Statements
suggest
that involve the
something
police and prosecution team.
here. I'm well aware of the fact that there's some discovery issues here, but they don't seem insurmountable to me. And they seem like something that could be worked out. The defendant's in custody. You are and have, as is your right, litigating the issue of her detention. And my solution to that, it's not my decision one way or the other, but it's in front of the SJC. But I feel that this is the type of case that is tried in the district court every day. It's a serious case. All cases are serious, but it's not complicated. And I want to set a trial date sometime early next year, and we'll get another discovery compliance date in a few weeks. Mr. Gubitosi starting a trial December 1st. So maybe in late December, we can have another compliance date if it works for everybody to try to iron these things out, because, it's, she is in custody. I'm cognizant of that. And so my solution, whenever, and we deal with this all the time, we spend sometimes more time dealing with the issues of pretrial conditions and release. And in the time we spend doing that, we could try the case. So this case looks to me, and I could be wrong, that it could be tried in a couple of days. And she's in custody. So if the case is tried and she's found not guilty, that's the end of it. If the case is tried and she's found guilty, that's a whole other issue. But the fairest thing, it seems to me, is to try the case as promptly as we can. So before your schedules get any more backed up, I want to set a trial date. You can always revisit it, but what about sometime in late January, February?
That's very fair, Your Honor, and I appreciate you saying that. And I wanted to ask maybe the first week of February.
Sure. Mr. Gubitosi, how's that work for you?
I have a murder starting on the 26th of January, so if we can go to, I could do this the week of the 9th.
Okay.
That's fine.
Does that work for you, Mr. Bradle? Ms.
Yeah.
Attorney Coakley?
Always with the caveat that I haven't checked with any witnesses.
Of course.
Sure.
And but this way we have a target date. Everybody can check with their witnesses. We can find out and iron that problem out now. And if there's somebody who needs an adjustment for a few days, a week, one way or the other, we can work on that. But the longer we wait to do it, the more backed up we get. And again, we're going to prioritize this case. She's in custody. Maybe she will be at that time, maybe not. I don't know. But at best, for your client, she's going to be on restrictive conditions, and that's a factor as well. So let's get a trial date now. Let's shoot for that. We'll schedule it for trial on February 9th. I think that's very reasonable. And let's set another discovery compliance date that everybody can live with sometime in December. Mr. Gubitosi, you expect to be tied up for a couple of weeks?
Yep, I think I can, the week of the 15th, I should be.
Okay.
I'm going to ask for maybe the 18th along those lines. I think we're in the same process.
We can do that. Sure. We'll do the 18th. And my purpose that day,
Sorry, Judge, it's a calendar issue. I'm sorry.
okay, all right.
Yeah, I got the question over at X. Why don't you just plead out to a lesser to the charge that is still there? If she does, she has not even a snowball's chance in hell to see her child again for literal years. Because currently, her ex-boyfriend is suing her for future child, what do you call it? Future child support, demanding she sells her house, which she needs as a security to keep paying her defense attorneys. She will lose all kinds of custody if she pleads to anything here. So it doesn't really matter if she gets probation for a plea deal or a year in prison if she goes to trial. Because then she will definitely lose her child. So just answering that question from over at X. Yeah. So while she was in hospital, having surgeries, he sued her for future child support, demanding she sells her house to pay for it. He's doing everything he can to get the child away from her. Now, folks, her postpartum depression was severe. At the time, it made her do a very, very stupid thing, like, as she says, as she claims, pulling a gun on herself. For me, in my personal opinion, the entirety of this situation, if you are folks, if you are a real man, you help the mother of your child. He chose to abandon her. Wait until the PPD got really bad. File this, let's steal the baby from her. This is what caused this situation. that she didn't get the help she needed. And the reason for that? Well, imagine being abandoned at your time of need. The person you thought loved you, more or less, spits in your face, tells you to fuck off, moves away, and gets a new girlfriend quite immediately after. If you're already in PPD, that would make you spiral. So yeah, now you can claim I'm wrong, but for me it's an obvious what the choice would be for a real man is to, even if love is gone, even if it's hard, you don't abandon people. You don't. And in my opinion, he not only abandoned her. He basically spat in her face while doing it. All right, let's listen to. It seems like we're getting this trial somewhere in the first few weeks of February.
18 is a tough day, it turns out. Could we do the 19th?
I'll do it. If Mr. Gubitosi is available, okay. We'll do it. Now, and I want you to have a conference, which I know you will, to see if you can work these things out or to refine or narrow the motion. And we'll revisit those things that day. I have a Zoom that's coming from a different Norfolk that we have to get to right now. So it's either that or we get together late this afternoon.
Perfectly fine, Your Honor.
Okay.
I think we can resolve much of the rest of it.
Now, as far as your request, the last thing I'm going to cover is your request regarding transportation of the defendant. I allowed it today. I'm going to do it on a date-by-date basis. I mean, if the next date is discovery motions, I don't think that it's necessary to transport her. If you want us to try to do a Zoom, we'll attempt to do it. But the goal here, again, in fairness to the defendant and everyone else, is to get the case tried promptly. So we'll have a hearing that day. I'll try to, or me or someone will iron out all of these issues if we can, and let's keep moving. I don't expect, doesn't sound like you intend to litigate a motion to suppress in this case.
Correct.
So that removes one common obstacle to getting this done. So working with that, I think everybody's being reasonable in terms of time. Why don't you have a further conference, exchange written responses so that there's down the road, there's no misinterpretation, and let's see each other again in a few weeks. And I'll order a Zoom, Habe, if we can do that. Okay? All right.
I think that'll be fine. If there's any issue, we'll file appropriately.
And if you have a narrower motion, or you can narrow the issues, file another motion, and I'll make sure that I get a look at it, or somebody will.
Thank you.
All right, thank you. Have a great holiday. All right.
Thank you, same to you.
Okay.
And as you see, the last thing she does is waving to her family, mouthing, "I love you," because she's going back to jail. This case is so sad and unnecessary. And as I said a moment ago, it all comes down to they had a child. She got postpartum depression. He chose to abandon them, spit in her face. Basically, that's what he did. Filed without her. I don't think she even knew about that that filing to take the child away from her. Either way, I will keep following this case. I will do a bullet point so we get the correct timeline going. I will put up a video. I have to find the timeline first, and then put it out as a separate video so we get all the basics done. All right, folks. Thank you. Thank you to the Young Jocks for finding, because none of the usual core TV or stuff like that shows to stream this. So Young Jocks got a hold of it and put it up on his channel. So thank you so much for that. So the rest of us could restream it and comment on it. And thank you guys for being here. Thank you. And let's see here. Thank you for Sebastian Müller, member for 23 months. Thank you to Konja Schmidt, gifting 5 memberships. Thank you to Dear Reader Normal People for gifting a membership. And thank you to Derek Croissant for your £4.99 super sticker, which was... What's that? Something with the cloud saying hiya. Yeah. All right, folks. That is what I had for you for today. And thank you so much. Check my other videos. And I will see you all in the next stream or video. You all have a good one. See ya. Bye-bye.
Sail the raven waves, brothers, axes high, shield strong. From distant lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fire.